and where not to go wrong. So we're going to focus on that today. This is interactive. I've got Menti on the ready. I hope you all have a tablet or phone or something where you can punch in the code and let me have your responses. There is also a question mark at the bottom of the slide. I am more than happy to take questions. You can ask me as we go along. You can ask me at the end. I honestly don't mind, whatever works best for you all. And throughout the workshop today, I really would appreciate as much interaction as possible, because I know redundancies inside out. So I'm here for you. I'm head of employment at Right Hassle, and I spend a lot of time advising businesses on how to do things wrong. But equally, I spend a lot of time advising businesses on how to get out of a pickle. So I would prefer to teach you the first, how to do things right, as opposed to how to get out of a pickle. I have my paralegal with me today. Her name's Georgia. Georgia can give everyone a wave.
Hi.
So Georgia works very closely with me and is part of my team at Right Hassle. And Georgia will control the slides. I'm not that great at multitasking. I'm here to teach you. So it should all run smoothly, but let's crack on. And hopefully you all enjoy the session. So what are we going to focus on today? I'm just going to quickly minimize my screen. Okay, so today's focus is going to be on 3 fundamental aspects of a fair redundancy process. The first is a genuine reason for redundancy. The second is meaningful consultation. And the third is how to fairly select an employee. If we can get those 3 things right, and if you walk away from this presentation today knowing more about each of those 3 aspects, you will be well on your way to avoiding a tribunal claim. Okay, so let's start a little bit of interaction. So you've got your Menti code on the top of the screen. I'm really keen on understanding what redundancy means to you. So I know my legal side of redundancy, but you guys tell me, what does redundancy mean to you? It means the job no longer exists. I agree. Okay. Okay, I like these answers. So someone leaving the business due to it changing. The company has no longer got a job for me. Role no longer needed. Letting staff go in a fair and equitable way. Job no longer exists. This is great. So in a nutshell, what you're all agreed on is the fact that redundancy to you all means that a job no longer exists. And that's important, because you've all quickly distinguished that it's not about a person who no longer has a role in the business. It's the job that no longer exists. And we're going to explore that a little bit more. But I'm really pleased you've all grasped the basic of why roles are made redundant, and one of the fundamental reasons as to why that happens. So a redundancy situation in law. So there will be a variety of reasons as to why a business will look at making redundancies. And you've all gone for primarily option number 2 on this slide, which is a job no longer exists. But actually there are a few others, which we will now just have a few moments to talk through. So the first one I've put on here is a new systems in the workplace. This happens quite frequently when an employer gets in a new particular program for their computers, or they have new machinery, which means the role that an employee has occupied has reduced or has diminished entirely. The job no longer exists. As you've all pointed out, that is a valid reason for redundancy. And what actually happens quite often is a job will no longer exist because of a reduced requirement for that particular role, or because an employer has considered restructuring that role. So the original role no longer exists. And that can also be a fair reason for redundancy. The third option on this slide, workplace is closing. Unfortunately, this is something which I have come across most recently as a result of COVID and the effects of the pandemic. So there will be situations when a department has to close in its entirety and everyone in that department is affected and made redundant. But there will also be situations when actually a business closes, and unfortunately that will result in redundancies too. The fourth I've put on here as business relocation. Now this one does not come up too often. However, it is a legitimate reason for redundancy. Most contracts of employment will include a mobility clause, which means that a business can change its location and the employee is required to move to the new location as their place of work. But every business relocation has to be reasonable. So if a business relocates to 30, 40 miles from the original location, that would potentially be considered unreasonable. And in those situations, employees are entitled to be made redundant, as opposed to being compelled to attend a new workplace, which is, 30 or 40 miles away, as I've mentioned. And then the fifth reason, which is just as popular or ties in with number two, is diminished requirement to complete work of a particular kind. And put simply, what that means, whatever that employee's role is, either part of it or all of it, there is less requirement for that employee to undertake it. So those are the 5 main reasons as to why a business can perform a redundancy exercise and know that that is a fair, legitimate reason considered in law. So I have another Menti for you all, and I'd like to know why you think it's important to establish a legitimate reason for redundancy.
It's coming up, Tina, Georgia, as a thumbs up, thumbs down. So we've only got ability to say we agree or don't agree, I think. Is everybody else the same?
Yep.
Oh. There's our first technical hitch. Apologies. It was meant to be a Menti. If anyone would like to put their responses in the chat, that would be great. Or more than happy to hear your reasons if you want to come off mute. So, Mike, I like your response to treat people fairly and avoid comeback. I'm guessing you mean unfair dismissal claims. To avoid disputes, absolutely. I mean, I can see that we're all aware that employees can bring unfair dismissal claims, and when we give advice or when we start a redundancy process, our aim has to be to avoid that tribunal claim. But also it's worth pointing out that actually getting it wrong creates reputational damage too. if you are unsuccessful in tribunal. Any judgment is a public judgment, and therefore you have to be aware that getting it wrong can cause or create some reputational damage too. We're going to work through a scenario today, and our agency or our business that we're all going to work through is called Flats to Castles Estate Agency. So this business has suffered a decline in sales and is now considering their options in respect of the fact that their financial loss has reduced, that they have suffered, financial loss. So they need to make savings, and that's perfectly okay. They need to make some savings, and they've decided, well, okay, can we make savings by making redundancies? And they've identified two departments, so that's sales and booking. The sales team consist of 3 members of staff, and they want to reduce it to 2. And their reasons for that are because not many individuals are selling their houses anymore. And the bookings is manned by one particular person, but due to an increase in online bookings, the business feels that they don't need a particular person undertaking that role anymore. So let's meet the employees. I believe you've all received the information in relation to these employees prior to our workshop today. So I'm definitely not going to read them out, but I will just highlight a few things about each one. So employee 1, her name is Jessica. She's obviously very popular, according to this bio. She's historically been one of the highest billers in the team. She makes great sales. She knows her stuff, and she's recently been on maternity leave. She's not actually due to return for another 3 months. Her line manager is slightly disappointed that he'd hoped that she might return after 3 months. And she also wants to commence flexible working and will therefore be pursuing a flexible working request. So in her team is also John. So John is one of the youngest in the team. He's had no absences in the last 12 months. He's very, very enthusiastic. His figures were awful, but they've improved. He's great on the IT and the database. He can be very boisterous, and he's had to have a warning about making an inappropriate joke, which caused offence to Michelle about her age. Our third employee in the sales team is Sky. So Sky, she's been with the company for over 5 years. Generally no issues with her at all. Her sales have climbed. She's got a great disciplinary record, there's nothing on it. She rarely ever takes time off sick. She's reliable. She'll put in the extra hours when she needs to as well. And then we've got Michelle. So Michelle, she's part of the admin team, so not part of the sales team. And she is the lady that's responsible for all the bookings and the inquiries. She's the oldest member of the team at 55, been with the business 18 years, considered pretty much part of the furniture. Her work is consistent and steady. Timekeeping, sometimes a bit erratic. She suffers from arthritis too and has to attend hospital appointments. She's not the most up to date with technology, and she recently got upset when John in the sales team, who we just met, made a joke about her age. So, bearing in mind we've now discussed or gone through potential reasons for redundancy, you've met the employees, and you know the rationale behind Flats to Castles reasons. Let's figure out if we think these are fair reasons or not. So sales team, the business wants to reduce 3 to 2 because of the housing market, and bookings, they just want to get rid because they have a system in place which they think performs the role of what the employee has been doing on a day-to-day basis. I'd like you to all use your Menti. There's some options for you to pick from, and I'm interested to know which options you will go for, and if you consider the reasons given are fair or not. So far, everyone thinks both reasons are fair. Okay. So we've got five of you that believe both reasons are fair. Just out of interest, if anyone's willing to come on the chat, did you think they were fair before we went through the legitimate reasons, or since we've been through the legitimate reasons? Okay, this is good. So Michael and Jay, you both consider they were fair anyway. Okay, this is good. I'm very pleased with these responses. Great. Okay. So we're going to talk now about pools. So we've considered whether we've got a legitimate business reason, and we're okay with that. We know who's at risk, and we know why the business wants to make redundancies. So the next thing we need to figure out as part of any fair process, before we even start engaging with the employees, is whether we need to use a pool. Now, let me explain to you what a pool is in employment law. A pool is when you put together people who do the same job or a similar job, and it will apply in cases where so many people do the same job, but you only want to reduce headcount by a particular number. And whilst you may have in mind who you would like to make redundant, and you may have your reasons for that, in order to be fair and transparent, which is so important in a redundancy process, you have to demonstrate that when you decided who was made redundant, you considered the use of a pool. So a pool would very rarely be used in cases where they are standalone roles. In fact, we call them in employment role unique roles, because there is no one else in that business that does an identical job or a similar job, or a role where there is interchangeable duties with the unique role. So in those situations, we wouldn't consider using a pool. But when you've got a number of people whose roles are interchangeable or similar, and they don't necessarily have to possess the same job title, but they just undertake the same type of work on a day-to-day basis, then you have to consider using a pool, and you have to then consider scoring those people in that pool. So whilst you might go into a process thinking, I just want to make one person redundant from this particular team, you essentially have to put the whole team at risk if they all occupy the same role on a day-to-day basis. We're just going to pause to just talk about this particular case. I've not put much case law in here, but I think there's a few that are relevant and are interesting. So this is a case involving Wrexham Golf Club and Ingham. So Mr. Ingham, he was a bar manager, and he was basically made redundant. And the club decided that whatever duties he can do, it could be done by other bar staff in the club. So unfortunately, he was made redundant. The tribunal considered that his dismissal was unfair because they thought that the club should have used a wider pool. And on that, excuse me, on that basis, they deemed it unfair. The appeal tribunal, however, overruled the main tribunal's decision and said, actually, it's not the job of the tribunal to decide if they should have used a different pool, but to decide whether the pool that was used was fair. So in respect of this particular case, the reason why I find it interesting is because based on the facts, I would not have considered using a pool at all. It's not relevant. If the bar manager is the only person in that club with that job title, then it makes no sense for him to be pooled with anyone else. And if the club had decided that actually we can make the cost saving by dispensing of the bar manager role, and whatever duties he does can be done by other managers in different roles or can be covered by bar staff, then that is perfectly fair. The reason I wanted to just pause at this case is because the issue of pools comes up frequently in tribunals. So it happens in scenarios where employees feel that they were in a pool and they shouldn't have been, or when employees who were not in a pool, they consider that they've been made unfairly redundant because they should have been in a pool. So getting the pool right is absolutely crucial.
Can I ask a quick question there?
Yeah.
So I'm just trying to understand the boundary there, because if you've got a bar manager and 6 bar staff, and the bar manager's the only one full time in the bar because the bar staff also do serve coffee somewhere else in the building or something. If they were full time bar people, presumably you would be a pool, but it's because they're part time and have another role which you can't make redundant.
No, that's not strictly correct. So their status in terms of part-time, full-time, it isn't that significant. What's significant is their day-to-day job. So the bar manager, I would assume, has additional responsibilities to bar staff, and his job might include doing PDRs, ordering drinks, ordering the stock, managing the timetable, for example. So his role is not identical to bar staff. And therefore, because he occupies a unique role, he should have only been a pool of one, or how I call it, he doesn't need to be in a pool. He should be considered as a unique role.
So the key is the fact there was a significant part of his job was unique to him.
It was, yeah, it was absolutely. So if there was 2 bar managers and one was full-time and one was part-time, that wouldn't make any difference. Then they would have to be in a pool. But because he was the only bar manager, there was no requirement for him to be in a pool with the bar staff.
Thank you.
Okay, so we're going to then, so you've considered your pools as well now, whether you need one or not. And then we need to move on to actually getting on with the process. So you've done the homework. The homework is the most important part of starting the next process. And the first thing you're going to do is place employees at risk of redundancy. So you must absolutely never confirm redundancy until you have gone through a process of placing employees at risk of redundancy and engaging with those employees before you confirm an outcome. So what we design for our businesses that seek our help is a at-risk letter. You might have heard of this before, but what an at-risk letter will cover off, it will explain, first of all, the business rationale for placing roles at risk of redundancy, and that should always align to one of the reasons we've already been through. If you are in a pool, for example, the sales team, it will confirm that fact that you are in a pool of 3 and the business wants to reduce headcount by 1. The letter will also make clear that no decisions have been made and that the business wants to progress with a period of consultation. And the letter should then make clear that the employee is invited to attend a consultation meeting. And there has been a lot of redundancies of late, and those consultations have been occurring by Teams or Zoom, and that's absolutely fine. You must always allow an employee a right to be accompanied. And before you delve into consultation, you must be in a position to have already considered any alternatives to avoid a redundancy situation. So that will be the first letter, and that will be the shock letter. When an employee receives that letter, they will instantly have a lot of questions. They will more than likely feel, why me? And they will become quite anxious. So this is where the process actually starts gaining some momentum. So we're going to have a look at what does fair selection mean to you. And we have a number of criteria that we're also going to look at, which I want you to work through. But I'm interested in knowing from using your Menti codes, what does a fair selection actually mean? Objective criteria, selection against a scorecard for the role. So all relevant factors have been considered. Okay, I'd like to know a little bit about what we think that might be. No preconceived decision. Be aware of protected characteristics. Yes. Okay, so I like these responses, and it seems to me that you have an idea as to how you should approach redundancies. This is good. I noticed we have one response saying all relevant factors. If that person would like to speak, by all means come off mute, but I'm quite keen to know what we mean by all relevant factors.
Are you prepared to admit who you were?
It was me. I'm not quite sure what your question is, Tina.
Okay, so when you're selecting, when you're in your situation, you have to make redundancies, and you're thinking, I've got to select someone. What does it mean to you in terms of how do I select someone fairly? So don't worry about what the law says that you should adopt, but how would you come about selecting someone in your mind fairly?
Well, I would sit and think about what things I need to consider and list them all out. And I would probably ask the people concerned too, if the list was complete or there were other things we should consider, to make sure that we're not forgetting anything or missing out something that afterwards will be deemed to be important and relevant and we've not considered it.
Okay. We will look at that in a little bit more details. Thank you for coming off mute for me. Consider protected characteristics, absolutely, but that does not mean that you can't make redundancies, and we will look at that again. Objective criteria, yes, objective criteria is the easiest criteria to justify. And no preconceived decisions. Yep. So what we say is redundancy should not be a foregone conclusion. And actually, most tribunal claims will, from an employee, will have that as part of a claim. So very often a lawyer will say redundancy was a foregone conclusion, and then they'll tell me why it was a foregone conclusion, and then I have to prove it wasn't, because if redundancy is a foregone conclusion, the dismissal is unfair. Okay, so we've got a lot of criteria here, and it's a mixture. I'm not saying these are all right or wrong. I just wanted to put some out on a slide, and I wanted to work through with you all how many of you felt that these particular criterias were fair or not. On your Menti, I think there are voting buttons which you can pick. So I thought we could work through yes or no. Anyone wants to come off mute and chat to me, that's fine too, or use your chat. But let's have a look at what sort of responses we get for these criteria. So do we think that length of service is a fair criteria?
Could I just ask a question? When you say consider fair for redundancy or fair for not to be made redundant?
Fair to make someone redundant, sorry.
Because of.
Yeah.
Okay,
so so the context of this is when you're selecting employees for redundant,
yeah.
You know, what do you take into consideration some of these bullet points, or do you not? Do you think they're fair to take them into consideration or not?
Okay, thanks, Tina.
Yeah, no problem. So we've got, I believe, if I'm reading this right, 3 yeses and 2 no's on length of service. Let me tell you, the correct answer is it can be considered as part of a criteria to make someone redundant, but only if you apply it in the selection pool. So one of the things that we don't like, or employees don't like, and will present claims is if an employer uses last in, first out. So they will take a view that because they're last in, they've been dismissed, and that means their dismissal was unfair. In law, last in, first out is not ruled out. It doesn't make it unlawful. The only time you have a risk is if someone that's been in the business for a short amount of time might, for example, be younger and therefore feel that there's been discrimination. But equally, someone who's been with the business a long time and has been made redundant might feel that that is because of their length of service and therefore because of their age. So using length of service is fine as long as it's not the only criteria that you use in a selection matrix. Age. Let's have your votes on age, please. I think I've touched on it. No. Okay, a lot of no's. Absolutely. I won't dwell on this one. Age should never factor in any selection criteria. Absence levels. Yes. So absence levels is okay, so long as you have set the period as to when you are looking at absence levels. So it's not okay to score someone bad because over the last 5 years, they've had a lot of absences. So you have to set the criteria, and that same criteria has to apply to everyone in the pool. So it might be that you look at the last 12 months, which would be deemed reasonable. But also, be mindful that if an employee has been absent due to long-term sick and they have a disability, or if an employee has been absent due to maternity leave or pregnancy leave, those sorts of absences should be generally disregarded. Employee has raised health and safety concerns. Great stuff. Good answer. Yes. If an employee is raised a concern and they are then made redundant, there is always going to be a risk that that employee feels that they have been made redundant because they raised a health and safety concern. And sometimes businesses can find themselves in a tricky situation, because actually the fact that an employee has raised a health and safety concern has nothing to do with the fact that an employee was made redundant, but the employee will look at the two events and link them together. So it's always best not to take it into consideration at all when adopting a criteria. The next is performance. Performance and disciplinary, let's take them two together. Okay, I can see a lot of thumbs up. Great. So again, with performance disciplinary, a bit like absence levels, it's fine. It's fine for you to include those criteria in a selection matrix, no problem at all. However, disciplinary record is likely to be an objective criteria, because it's limited to looking at someone's personnel file and having a look to see whether they've got a warning, for example. Performance is likely to be a bit more subjective, unless you have a particular way in your business where you objectively review performance because of targets, for example. That can be a bit more subjective. However, again, you must look at performance and disciplinary in a time frame. So you should potentially be looking at the last 12 months and not over the lifetime of the employee's employment. I'm going to take the next two together as well. So sex, maternity, paternity leave, should they ever be taken into consideration? Absolutely, you've all got it. No, they should not. However, there is a view that because an employee is on maternity leave, or has been on paternity leave, or has recently returned from maternity leave, that you cannot make that person redundant. That's incorrect. It carries a lot more risk, of course it does. However, you can make employees redundant if they have been on maternity or paternity leave. There are some special considerations, however, for maternity leave employees, or employees that are pregnant and have not gone on to maternity leave. So please make sure that if you do consider making redundant a pregnant employee or a employee on maternity or paternity leave, that you do just pause, take some advice before you proceed. Timekeeping is the next one. How do we feel about including that as a criteria? I think we've got mainly yes. If anyone, by the way, completely disagrees, please please speak to me and I'm happy to talk it through. But timekeeping is okay. It's okay to add to a criteria. You do need to be a bit careful though, because the problem with timekeeping is if you don't discipline someone's poor timekeeping, then arguably why have you suddenly used it as a criteria to give them a low score? So I'm not a massive fan of looking at timekeeping as a criteria. I think it's better to stick to looking at someone's disciplinary record. If you have employees in the business who have poor timekeeping and you haven't addressed it, then it doesn't seem fair to me that they are suddenly scored less favourably as a result.
Can I just ask, if you operate a flexible working pattern where you haven't got sort of set times to start and finish, but you feel that somebody is sort of taking one in terms of the amount of time that they're actually putting in, can you sort of look at that as timekeeping?
So in terms of, so if an employee has a set amount of contracted hours, but they can work flexibly, I think the first thing you've got to look at is how do you know that that person is not undertaking those contractual hours? I think actually it's probably better to look at performance. I would have thought timekeeping affects performance. Because if they're not putting in the hours and they're not turning up on time, and performance is subjective criteria, I would rather you suggest that performance is not a 5, it's more of a 3, which is a lower score, and one of those reasons is because their timekeeping is poor. Does that make sense?
Yeah.
But I'm not, I mean, I'm not saying you can't use timekeeping. I just think it causes a lot of questions. And a tribunal will say, well, if it was that bad, why didn't you go through a disciplinary process? And I try to avoid that.
Yeah. Okay.
Okay, great stuff. So I feel like you'll all know the answer to this, but should we take in consideration disability? Yeah, we are on a roll. Absolutely not. We should not take into account disability. Also, I think I've touched on absences and disability-related absences. So they can sometimes be intertwined. And that's why I said at the very start of when we were talking about absences, please disregard time off in relation to long-term sick if it's been because of a disability, for example, or if someone's had an operation. Because those sorts of absences, they can be one-off for starters, but also they can affect the fairness of the scores. From Mike. But what about a new role that, oh, sorry, Mike, I'm just going to get you to chat up again. But what about a new role that has physical requirements? Okay, so in terms of taking into consideration disability, what we're suggesting is that should never be a criteria to say why someone should be made redundant. But if you have a role which you are advertising and it's an intricate part of the role that an employee undertakes a fundamental element, for example, they have to climb up ladders and it's just not possible. It's just not possible because of the employee's disability, then you have to be transparent. You have to make sure that you have made it very clear what the requirements of that role is, that it's intrinsic requirement, and it's always better to have an occupational health report or a GP report, not necessarily needed, but better. So you've got that paper trail. We love paper trails in employment law because they prove whether something most of the time is gone right or gone wrong. And if you're able to demonstrate that there is a reason why you cannot make reasonable adjustments to a role because of the elements of that role, then that's okay.
The reason I asked that question is if you've got like a factory,
yeah,
you've got someone who's got a desk job in that factory saying dispatch,
yeah,
and you all of a sudden have to cut numbers and give people increased responsibility in a factory, and I've got people here, there is then a requirement to carry and lift things, which that desk person may or may not be able to do.
Yeah, absolutely. And that, you know, what we were talking about, one of the fair reasons for redundancy and restructuring a role is, and unfortunately, if that situation comes up, whilst you can't take in consideration disability in the criteria to make them redundant, what you should do is always allow everyone the opportunity to apply for any new role that might exist as part of a restructure. But you should create a job profile, and that job profile must make it absolutely clear what are the requirements, and the employee and the employer should talk about the requirements of the role as well if that employee applies for the role. If the employee is made redundant and suggests that they were made redundant because you weren't prepared to accept them undertaking a particular role, what you've got to have in place is the consultation that you're going to go through, your interview process, your job profile, make it clear, so you can avoid an assertion that you simply did not take someone on because of your view that they can't do a particular role. Is that helpful? Okay. we're going to look at, oh, so we've got a few more to go through. So we've got flexibility. So whether an employee is flexible, that doesn't necessarily mean we'll do overtime. It means that they will undertake other duties, for example, they will help other teams. Do you think that's fair to include that as a reason to keep someone or as a reason to make someone redundant? Okay, so we've got a mix of answers here. That's interesting. So flexibility is a subjective criteria, and therefore it will be considered based on the opinion of the person who's undertaking the scoring. So one of the things that you have to do is first of all consider what you mean by flexibility. So is it that someone is willing to work extra hours? Is it that someone is always willing to do overtime? Is it because that person is will help other team members? And you're able to actually include flexibility in a criteria, but you've got to be very careful because it's subjective. So there is nothing you're not going to be able to convince a tribunal that you were right or wrong. You've just got to be able to demonstrate to a tribunal that the reason a person got a particular score for flexibility is because, and then give those examples why. Membership of a trade union. Do we think that should ever be taken into account? That's absolutely correct. It should never be taken into account. Good stuff. Skills, qualifications, and experience. I've put them two together. Yeah. Agreed. They can be taken into consideration when creating your matrix. That's not a problem. Experience is a bit more subjective. Skills and qualification should be objective. There should, you should be able to easily establish if someone has the requisite qualifications for the role, and that therefore scores them higher or it scores them lower, whatever the case might be. Experience is likely to be subjective because it'll be the view of the line manager or the supervisor who is considering whether that person actually is able to do that role autonomously, has the experience to work efficiently. So you can think about experience, that's okay as well. Employee has blown the whistle. In law we call that protected characteristic, not protected characteristic, sorry, we call it the employee has blown the whistle is a situation when an employee will report a wrongdoing. So it will report a wrongdoing either to someone internal or it will report a wrongdoing to someone external. And employers should not, as you've all correctly pointed out, should not take that into consideration. Okay, so the final one we're just going to look at is marital status. And what do we think about that? Agreed. Definitely don't ever take into account marital status. Okay, thanks so much for going through the voting with me. That was really interesting. Has anyone got any questions from that criteria exercise? No. Okay. So what you're now looking at is a typical fair selection criteria. So encapsulates a lot of what we've actually just agreed should be included. And you can see that it's a mixture. It's a mixture of subjective criteria and it's a mixture of objective criteria. And I would always encourage that you include subjective and objective criteria. when you create the selection matrix and you choose what criteria you want to rely on, you have to consider how you are going to score. So lots of employers will use a range. So for a range between 1 and 5. So 1 will be X, 2 will be something else, 3 will be something else. A tribunal is entitled to look at your criteria and is entitled to look at what was allocated for each scoring. So it's really important that you do that beforehand. You choose your criteria, you figure out what you want, what a 1 looks like, what a 2 looks like, what a 3 looks like, and so on, before you actually apply it. Okay, we're going to go on to consultation, and the really so important part of a redundancy exercise. So consultation, that is when you talk to the employees, they've had their at-risk letter, they know they're in a pool, or they know they're a standalone role, they've been invited to come and talk about what could potentially be their redundancy. And it's really important that even when you enter consultation phase, that you do not suggest that their redundancy is a foregone conclusion. And as we've seen, or as we will see, there are many cases where if you don't consult, you will just lose. You will just lose at tribunal. And that's why it's so important that you build this into your redundancy process.
Yeah. Just ask, is there a period of time that you should consult for?
Okay, so what we're focusing on is redundancies that are below 20. That's a significant number in employment law, because some of you might have heard of collective consultation, and that applies where there is a lot more employees that are being made redundant and you have to follow various consultation legislation. But when you've got less than 20 employees, it's always recommended that you hold 2 consultation meetings at the very least, and you can generally complete a consultation within 2 weeks. So in terms of the process, when you send the at-risk letter, always allow 48 hours clear notice from when the employee received the letter to when you hold the consultation meeting. And as I said, it's okay to do it by Teams and Zoom, that's fine. The purpose of the consultation meeting might feel a bit scripted. It might feel scripted because you've given all the relevant information already in your at-risk letter, but that's okay. You should still go through it with them. So the first thing that you should address in a consultation meeting is the business reason as to why their role is at risk of redundancy. If the employee is in a pool, you should explain why they are in a pool. If the employee is in a standalone role, explain why you consider that a cost saving can be made by potentially making that one role redundant. It's really important during the consultation stage that the dialogue is two-way. And therefore, you're asking the employee if they have any ideas to avoid redundancy. And they might come up with some ideas, for example, reducing their working week, a job share, reduction in pay, and all those ideas are fine. Do not deliver an outcome of those ideas at a consultation meeting. And the reason I'm saying that is because if you immediately give a response, then you will not be able to convince a tribunal that consultation was meaningful, because you didn't take that response away and give it some thought before you delivered the outcome. So engage with the employee during that meeting. Also, advise the employee in that meeting if there are any vacancies across the organisation. So one of the questions that I will get asked quite a lot during redundancy exercises for clients is, do I have to let them know about this particular vacancy? And the reason I will get asked that is because the employee will automatically take the view that there's no way that employee will go for that job, or they don't have the qualifications for that job. So why should I tell them about that vacancy? That isn't for you to decide. the rule's quite simple. If you should just provide each employee with a list of vacancies. That does not mean the employee will necessarily apply to every vacancy. And it definitely does not mean that even if the employee did apply for every vacancy, that they would achieve a role. Your requirement is simply to make sure that you have provided that employee with a list of vacancies. Once you've completed the first consultation process, immediately have the minutes typed up if they were handwritten in the first instance, and then consider some of the alternatives, if there were any, that the employee made during the first consultation meeting. Your next step is then, if they're in a pool, to carry out the scoring. If they weren't in a pool, you continue with the individual consultation. So I'm just going to split that process a little bit so we stick to learning both. So if they're in a pool, then you will carry out the scoring, and you will then send a letter to the employee with a copy of their scores, but also a copy of the scores of everyone else, with the names of all the other employees blanked out, however, but a copy of everyone else's scores, so the employee can go into the next consultation meeting seeing where they have fallen in the table. If they are an individual, a unique role, they should still have a second consultation meeting, and therefore both pools and individuals will receive a letter saying, here's the minutes of your first consultation meeting. As you know, you're still in a period of consultation. Your remote role is still at risk of redundancy. We'd like to continue engaging with you. Please come along to this second consultation meeting. And again, within a minimum of 48 hours after you send the letter. When
Tina,
yeah.
Sorry. The scoring.
Yeah.
So you don't do the scoring with the individual. You're telling the individual what scores they've been given.
Yes.
And do you have to declare who the people were that actually gave those scores?
Absolutely, absolutely. So because it would come up in tribunal, the tribunal would want to know, well, who carried out the scoring? So always think about who's appropriate to carry out the scoring. Sometimes two people will carry out the scoring because that seems appropriate. Very often it will be a line manager, because that line manager can certainly give some feedback on the scoring for subjective criteria. So at least one person who works with the employee, because of a supervisory role, should be scoring. That would be the best solution. I have known employers that have just relied upon objective criteria, and then in that situation, technically anyone can carry out the scoring, because the information that you're relying upon should be in a personnel file. So it doesn't matter if it wasn't the line manager. But very few selection matrices do not include subjective criteria.
And you also put weighting in there.
Yeah.
Again, a decision about what weighting you're giving each of those particular criteria.
Yeah. So, and that's something that you will as a business decide before you carry out the scoring. So for example, length of service, I would not put that as high weighting at all, but you want to recognise length of service, and therefore you want to have it in a criteria. Clearly performance would rate much higher, and therefore you would want to add more weight to that. So all these factors you can decide before you actually get into scoring mode.
Okay. Thank you.
That's okay.
Ask a question, Tina.
Yes, of course, Jay.
What if the employee or employees won't engage with the consultation or can't engage with it?
Yeah, I've actually had this situation. It's painful. It's very painful. However, you have to persevere. So a couple of options for you is, if an employee refuses to engage, then you have to try and rearrange. So always rearrange a meeting one more time. If they say, I'm still not engaging, I'm not having any of this, I'm not going to come along to this consultation meeting, then you can suggest, well, okay, let's do it by what we call written submissions. So basically you ask questions by email, they respond by email, and so forth, and you carry on that process. But if you have a situation where an employee just simply refuses, which I have had recently, won't even engage by email, the employer then had to, on my advice, carry out the consultation meeting in their absence, and still had to produce the minutes for me to show that he'd gone through the process, thought about the role, thought about the business reasons. And it seems a hollow process to undertake a consultation meeting in anyone's absence, but failure to consult carries too much of a risk for you not to follow that hollow process either. Is that okay, Jay?
Yeah, that's okay.
Yeah. Okay. So your still focused on consultation because it's so important. So when you get to the second consultation meeting, let's talk about the individual first. The unique role and that particular individual, it will feel very much a rehearsal of the first consultation meeting, because very often nothing's changed. The business rationale remains the same, and there's still no other alternatives that you can come up with. There are no alternatives that the employees come up with. And it might feel very short, that second consultation meeting. It might even feel a bit pointless. But you've got to persevere, go through that second consultation meeting to make sure that you've attempted twice to discuss and to avoid redundancy, but either party couldn't think of anything to avoid it. Now, if you're in the pools, what will inevitably happen from experience is that the employees won't be happy with their scores. So very often on the objective criteria, that's quite easy to fix. If you're relying on some information that was on a personnel file and we've got it wrong, we've got it wrong. However, the subjective criteria can sometimes cause a little bit of commotion. So if an employee disagrees, they disagree with why they've scored so low for performance because they've done all these wonderful things for the organisation, you must not make a decision there. You must not make a decision in that meeting to increase that score. You must hear that employee out and go away and think about it. It's okay to stick to your score as well. If you consider, no, I gave the right score based on what it is to achieve a 2, what it is to achieve a 3, for example. Or you might actually say, well, actually, I think that employee's got a point, so I'm going to increase the score. So if you get a lot of noise in the second consultation meeting, you then might need to have a third consultation meeting just to wrap it up, to make sure every query's been answered and you're back to no queries. It's really important you don't make redundancies when there are outstanding queries, because that will inevitably be a reason why someone thinks that no one was listening to them and the conclusion was a foregone conclusion. So there's quite a lot of info I've just provided you all there in relation to consultations. Please feel free to ask me any questions. I've put another case in just because I've talked about consultations and I'm guessing you get it, you need to consult. But here's a case where an employee was successful. It's called Heron v CityLink Nottingham. So in a nutshell, the employer didn't consult. They didn't think they needed to consult, and the employee brought a claim, and the Employment Appeal Tribunal very clearly said that dismissal was unfair. One of the things that I do quite a lot, and I mentioned at the start of this workshop, is I will try and fix a problem that's happened. And one of the situations that I will come across is employers coming to me, they've made someone redundant, that they've got a legitimate business reason, that's fine. They take a view that even if they followed consultation, it wouldn't have made a difference. That person still would have been made redundant. And I can believe that, but it's very difficult to convince a tribunal that the failure to consult would not have made a difference to the outcome. So this is why I very much promote consultation, and at the very least do 2. Okay, we're going to go on to, once you've gone through the consultation process, up to 2 weeks time, you will then go through the final stage of letting the employee know that their role is redundant, and that should always be done via a letter. Some employers will call the employee and let them know the decision and then follow up by letter, but always have a letter that confirms the termination. Within that letter, always worth pointing out that they've had 2 consultation meetings, always worth pointing out that you've explored alternatives, you've considered their alternatives as well, and why they're not viable. And then confirm the termination date, that unfortunately their position will be made redundant. You must confirm in this letter what their statutory entitlement to redundancy pay is. You must confirm whether you require them to work their notice or they will be paid in lieu of notice. But what you also must confirm and must never forget is their right of appeal. So you must always include that in your outcome letter. Okay, we're back to...
How long have
Sorry.
they appeal?
So right of appeal is generally governed by what is contained in an employer's staff handbook. So I tend to say 5 days, you know, appeal with, let me have your written reasons for appeal within 5 days, but your staff handbook might say in any appeal situations you have 10 days from the day of decision, but I certainly wouldn't go below 5 days at all. Okay, so Flats to Castles have made their redundancies. Jessica and Michelle were made redundant. John and Sky remained. You have the employee profiles. We went through Jessica. I've just leave it on the screen for a second. Michelle, sorry, there's Jessica again. In case you don't have a printout in front of you, just to familiarise yourselves with her profile. And then we've got our next employee who was made redundant, Michelle. Okay. If anyone needs to revisit them, just let me know and we can put them back on the screen. So this is where I'm going to send you all in a breakout. We've actually been through a redundancy process together, and you now know who was made redundant. And I would like you to consider the risks the business might have, even though they followed a redundancy process. So considering the information that you've been provided, what risks, I'd like you to tell me, do you think that Flats to Castles faced in making these 2 redundant? And what factors should they have taken into account when making the decision to dismiss? So Georgia is going to arrange the breakouts now for everyone. I will see you all in a few minutes. So we're back. Thanks, everyone. I hope you all had chance to discuss the risks. How should we do this quickest way? How about via chat? Or if anyone would like to come off mute, more than happy. What risks did we identify with these 2 employees?
Mike, quickest, so put your hand up and shout. Somebody from each group. Mike.
Well, obviously, maternity one, as a risk, whether that had been well covered for the younger of the 2.
Yeah, absolutely.
Yeah.
Mike, did you have something to add?
Yeah, we had absenteeism and the request for less hours from the younger one, Jessica, and then Michelle as an age thing, possibly.
Yeah.
She's got a bit of arthritis. And the other thing I thought was they could say, well, hang on a minute, you're getting rid of both of us because we're women.
Well spotted.
Yeah.
Well spotted. Yeah. So you're all absolutely right. So with let's look at Michelle first. So Michelle, the business had a legitimate reason. They, sadly, they don't need her because there's a system in place which can carry out those bookings. But she could say no, they did that because of my age. But that doesn't mean you can't make that employee redundant. Any claim, in my view, would be vexatious. And this is why it's so important that you follow the correct process. So you're able to show a tribunal that actually her age had nothing to do with the process at all. And that should lead to a successful win for the employer. And then with Jessica, so Jessica was actually on maternity leave and hasn't returned to work, and they made her redundant. So Jessica's redundancy was actually unfair. If they took into consideration her absence for maternity, that would have been unfair. So I was trickling that into our presentation. But also because she's a pregnant employee on maternity leave, she should have been given the opportunity to be given a suitable alternative job, not just been in a pool and scored the lowest. So in my view, Jessica's redundancy would potentially be considered unfair. However, I do think that Michelle's would be considered fair.
You probably wouldn't rush to make Jessica redundant because it's an absolute pit of snakes when they're pregnant. And it's not worth it because you might end up with another role down the line for them. You have to provide them a role when they come back, don't you?
Absolutely. And also, discrimination claims, they carry an unlimited cap. So there is always a huge risk when you make an employee redundant who's pregnant or on maternity leave, because if they're successful, they're likely to achieve a good award in compensation.
But you often go for a compromise, don't you? Or you give them more than they're going to get by
Yeah, good old settlement agreement. They're amazing for businesses because they wrap up an employment with no risk of the employee ever bringing a claim, but ultimately the employee's got to accept it. And very often, the settlement agreement has to have an incentive, a financial incentive, which makes the employee think, okay, do you know what? I'm just going to take this settlement instead.
I've always, with redundancies and things like that, always seen people better than I know they could get if they went for advice. They get asked, what did you get? And they say X, and they say, well, you're probably not going to get better than that. Yeah. I always play that game because I think it's not worth the financial headache. It's not worth the headache for the sake of another grand or two,
Yeah, I agreed. And management time, there's no price on that really, but the management time to deal with a tribunal claim is huge. Okay, so I'm just going to finish off with a few stats because we're still in a pandemic. And one of the things that I am regularly undertaking is redundancies, and I fully expect that is going to be more work that I will be undertaking in the very, very near future. The stats are on the screen. Redundancy dismissals are increasing. Unfair dismissals are increasing. The number of employees on payroll is obviously decreasing. It's so important that you follow a fair process, because the risk that you have with redundancies or any type of termination, employees don't have to pay a fee to issue a claim. And because redundancies, employees will take it very personally that they've been made redundant. They don't have a job. They're in a job market which can't offer them a lot of choice. Lots of employees will issue claims which actually have no reasonable prospects of success, but they will issue a claim. And your best defense is always going to be your paper trail of a fair process.
Is there any, that to protect from someone just putting up a spurious, I'm going to take you to tribunal? So
unfortunately, if an employee wants to bring a claim, they will bring a claim. But as in a business, what you can do is put an employee on notice of costs. So employment tribunals don't operate like other courts. The loser does not pay the winner's costs. But if a claim is vexatious or if it has no reasonable prospects of success, then you can make that assertion at the very start under cover of a cost warning letter, and you give the employee an opportunity. You say, withdraw your claim for all these reasons, and you go into lots of detail. But if you continue to present it and we succeed, and we've already given you a cost warning letter, then we will pursue you for our costs. And that's the only way you can try and dispense of a vexatious claim quite quickly.
Did you say, Tina, there is no cost to an employee in raising a claim? I thought there was a fee.
No, the fee got abolished and tribunal claims then hit the roof. Right. So there's no fee involved, none at all. Okay, so the last slide here is just it's a summary. It's a summary, and I think it's almost a full circle summary. So what we set out to do and what I hope that you've gained from today. So just to wrap up, everyone, please have your business reason when you're making redundancies. Follow the process, and I'm sure I've stressed that plenty of times today. Engage in meaningful consultation. And please select fairly. And if you do it all right, I should hope you don't have any claims. But be mindful. There are claimants or employees that will bring unfair dismissal claims, even when a fair process has been followed. Okay, thank you very much.
Brilliant. Thank you ever so much, Tina. That was really great. And thanks everybody else for being with us this afternoon. Because you spent an hour and a half with us, it's good to have something to take away. Most of you will know that we'll send you the feedback information for you to fill in, but Pam and Kevin, that should be being sent to you now. So if you could fill it in straight away, so that everything that's fresh in your mind, what are you going to take away from today? What's new? What didn't you know? What can you not actually employ Tina for now? Has anybody got anything quick that they can tell me before we end for today? Mike, go on. You always help me out. Muted. Yeah.
Something useful from today. I think, we've gone through some redundancies in our business, and Sharon is very well versed on it, but it's good to get a recap as well. And I always just think with all this sort of stuff, it's about fairness and preparation, really, and making sure, even in anything, even with interviewing, that you have records and scorecards, and you've got more than one person's opinion. When we made redundancies here, we took time to do it as a senior management team and score them to actually try and create a more balanced view. And then at the end of it, when we did some of it, it's also, when you let people go, let them go with dignity, and help them to try and find another role. And it's great if they can. And you don't want to make enemies, really, if you can avoid it. So yeah, I'd say that probably. And see them good if you can.
Yeah. Thank
Brilliant.
you.
Okay. Well, I know we're out of time now. So everyone have a great evening. Please fill in your feedback forms.
Yep.
And have a good evening.
Thanks,
Okay.
Tina.
Thank you.
Thank you very much.
Bye.
Bye.
Hold on. Yeah, good.